Brian Farrell is a associate professor of instruction and director of the Citizen Lawyer Program at the University of Iowa Center for Human Rights. Your PhD is from the National University of Ireland, Galway, and in international human rights. And you recently published an interesting title for an article called Habeas Corpus in International Law. I guess I was attracted to it because I was watching a series on the US Civil War when President Lincoln suspended habeas corpus. And so my eyes were attracted to that one in particular. It's a book with Cambridge University Press. So with that, Brian, you want to start off?
Yeah, it's always nice to hear that something is interesting to anyone. I appreciate that. So I talked with Jessica, and what I thought I'd share this morning is my current and fairly stalled joint project looking at rural access to justice. She mentioned that, with the idea of an upcoming roundtable, that might be a good fit. So this is a project that I've been working on with a colleague of mine, Daria Fisher-Page, here at the University of Iowa, for about 3 years. We started off, very optimistic, lots of energy, and then the pandemic hit and everything kind of got sidelined. Both of us have young kids and we are just getting back to it. So I said to Jessica, this is kind of a nice catalyst to think about it, kind of get back into that space. And what I'll give you is just kind of where this is coming from, a couple of what we saw as interesting observations that led us to want to look at this issue, and very briefly what our plan is. So I happen to be on the State Access to Justice Commission. I think the majority of US states now have established commissions on access to justice under their Supreme Courts, sometimes under the State Bar Association, looking at civil access to justice. Pretty clear divide here that these commissions are not looking at access in this criminal sphere. So I was working on that commission. Daria approached me and we were awarded a Bellow scholarship through the American Association of Law Schools to expand on this project, looking at rural access to justice in Iowa. And just a little bit of the framing and what we're looking at. Access to justice is a big topic. The justice gap, this notion that on the civil side, there are people who cannot afford attorneys, don't have access to attorneys, has been a priority for the American Bar Association for a number of years. It's an international issue as well. There are international human rights organizations that are looking at access to justice issues. Here in Iowa, again, the commission is probably about 5 years old. There's also a lot of specific attention paid to rural access, right? And the fact that there's a steep decline of rural practitioners, that these access to justice issues that have been identified are particularly, hard hitting in rural areas. But so what we wanted to do was look a bit at that and really think about the messaging, the narratives, and try to see what data is there to support that and what data is guiding interventions. And one of the things that we found is when we talk about access to justice, everyone kind of has their own conceptualizations. There is scholarship on the topic, but the scholarship is not necessarily related to the work that a lot of these state commissions are doing, that the ABA is doing. In other words, it's one of those amorphous terms that's kind of a catch-all for whatever people think. And one of the very clear things that we found is that when you have attorneys in the room trying to think about, discuss, and solve the problem, they place attorneys at the center of access to justice, right? They see attorneys and the presence of an attorney as corresponding almost directly with, increased or decreased access to justice. We also saw that in rural areas, there was often descriptions of a crisis, access to justice crisis and a rural attorney crisis. And we really wanted to interrogate that a bit because as a former rural practitioner, one thing that I recognized is there are a lot of small town county seat attorneys who do not do the types of legal work that benefits, the poor, the marginalized, or sort of day-to-day legal issues. A lot of them do work that is specialized. Many of them do higher end estate work. And so it just struck us that, we wanted to make sure that there was sort of a correlation between what was being described and what was actually happening. And again, to really make sure that these interventions were, on point. The other thing we recognized is, trying to decenter the attorney from the question of access to justice. We realized that in the rural space, bar associations, local communities, attorneys, law schools, again, we're really reinforcing this notion of the attorney as the only measure of and the only solution to access to justice. And that's kind of complicated because certainly there is a need for rural practitioners. Certainly there is an economic benefit to a community to have an attorney in the community. There's civic leadership that comes from having attorneys in the community. So there are these issues, there are these concerns about not having rural attorneys that are very real, but they may or may not relate to access to justice. The other thing that we discovered here in Iowa is with a lot of baby boomers who came out and started practicing in these thriving county seats in the late 1970s when the farm economy was strong. They bought into practices, they built them up, they have a safe full of wills, they have all these farm clients over the years. They have a going business that they want to pass along to someone. They see it as having a particular value, and they're thinking about succession planning. The Bar Association is interested in succession planning for these private attorneys, and not a lot of young attorneys want to go to rural areas. Well, part of that is young attorneys have $200,000, $300,000 of law school debt. They are being asked by these 70-year-old retiring attorneys to buy into a practice that the attorney sees as having this great value because that's what they did in 1978 when they had, $2,000 of law school debt. So the situation is just very different. So there's this crisis of retiring attorneys not being replaced that, again, I think is somewhat removed from the access to justice question. So what we're trying to do is really look at the data. And what we found is most of the data is supply side data, of course. We can look at the number of intakes that legal aid has. We can look at the presence of attorneys. We can look at where courthouses are. But again, all of this is very much centered on the attorney as the actor, or perhaps the court system as the space for access to justice. We have been trying to think, and we've been working with a geographer who does sort of vulnerability indices to try to think about, is there a way for us to find data that can serve as proxies for access to justice risk or access to justice need, right? Because someone who is in need of legal information, legal advice, legal services may not see it as a legal problem. They may not be approaching an attorney. So all we're looking at typically in commissions, the ABA, we're looking at who recognizes they have an issue, who decides to go to an attorney, who engages with an attorney. Only then are we measuring them, right? We're not able to capture who out there really has a problem that may go unidentified, that may be resolved through some other means. And so we are trying to construct kind of a model to think about access to justice in a slightly different way, especially in the rural space, thinking about demand for legal services, which typically does not involve an attorney. How can we facilitate better resources for those who have access to justice needs? The supply side, the legal services, but also think about legal information and advice. And that often is a difficult conversation in attorney-dominated spaces where, again, we see ourselves as needing to have one-on-one intervention with anyone who has an issue, where a lot of times what they need is, to know where to go to get information, to know where to find a form, to know what their options are. They don't necessarily need an attorney. And then third, kind of the resolution space, and to recognize that two of those spaces, both the demand and the resolution space, and to an extent, even this middle space of the legal information and advice, may not involve attorneys at all. Somebody can identify a legal issue, they can resolve it through online dispute resolution, through mediation without ever engaging an attorney. And one thing that sticks in my mind, we had a great presentation about a year ago from a scholar from Indiana University. And he pointed out that, in the medical side, 80% of services are delivered by non-MDs or physician assistants. 80% of medical services are delivered by practitioners, nurse practitioners, other lower level practitioners. On the legal side, 95% of services are delivered by attorneys. We see ourselves as the only ones capable of doing this. And so it's this, very, again, individualized industry. And that has its challenges to think about and talk with attorneys about whether there are other means of meeting people's needs in terms of, again, low end, attaining legal information, accessing, basic legal advice, but also even when it comes to legal services such as drafting or simple matters, maybe there are other alternatives besides attorneys. And even in the space of attorneys, that there are other practice models that might be more conducive to enhancing access to justice that are not, give me a retainer and I'll charge you that, a multi-$100 an hour fee. So that's kind of the project. That's where we're headed, trying to develop this model and think about, again, whether we can create some proxy data to help us identify greater areas of legal need risk, and then how to think about those interventions beyond kind of this common, only an attorney can be in the middle of it. Again, not diminishing the role of attorneys, but I think one of the best things for our commission was when we realized we need to invite and include non-attorneys who see these problems differently and who think about the solutions differently. So that's where we are. We're continuing to progress, working on some digital mapping to try to, again, capture that data, show the limits of it, and hopefully then, following up with more of a traditional piece of scholarship to talk about those interventions. And again, I think just interrogate some of these narratives in terms of, what does access to justice look like in rural areas, and what is the role of the attorney. So I will leave it there, and happy to appreciate any feedback and happy to answer any questions or have further discussion at any point.
Thank you very much. It's hard to do an applause on Zoom, isn't it? But thank you. That was really interesting. Let me start out with a question. A lot of what you said in the background is something that I used to teach a lot. I used to teach a course for police officers, that is sergeant up to chief, on community and leadership. And I would really emphasize the inequality of communities in terms of power and decision making. In the background of everything you said was the idea that even if you double the number of lawyers in rural areas, they would simply serve the rich. Would that be correct?
Well, I think that potential is there. And I think, again, part of it is just decentering the attorney as the only means of providing legal information, legal advice, and legal services, recognizing that, some people simply are not going to match with an attorney. A lot of the emphasis in this area has been on pro bono work. How do we get attorneys to do more pro bono work? But again, that assumes that the attorney is at the center of it all. So I think that, doubling the number of attorneys, it could have really great benefits for rural communities. It could have economic benefits, could have civic benefits, may or may not address access to justice in this way, especially if those attorneys are going in and practicing under the same economic models that attorneys, typically have to this time. I think we're seeing kind of this increase of community law offices, lawyers who are doing regulations have changed that allow lawyers to do unbundled services, right? So it used to be that if an attorney was involved in a divorce, once their name was in it, the judge assumed they were going to handle it start to finish. And most states have changed their rules to allow an attorney to come in and say, I'll do this part. I will help you in the drafting, or I will help you in calculating child support. that's made a big difference because it allows a consumer of legal services to say, I want to stumble through this on my own. I want to use these interactive forms. I am able to work with a mediator and my partner, but we need expertise for only this piece. And so that is available now, but only a few attorneys are doing it. There are attorneys and firms that are opening that are specializing in unbundled services, that are adopting new economic models, saying that, you know, we'll have sliding scale fees instead of, again, this traditional notion of, I'm not talking with you until you plop $5,000 down on my desk as a retainer, and then I'm going to charge you by the hour. Charging for services. I mean, this is a big change. This doesn't seem like a big change, but in the legal field, the idea of, I will give you a price for this piece of the case that I'll work on for you, instead of, I'm going to work on it and I'll tell you how many hours it took me and I'll bill you at an hourly rate, which is how lawyers have always done it. So I think that there is a possibility that if lawyers entered rural spaces in greater numbers with a slightly different mentality and a willingness to approach the business side of it differently, that it could have positive impacts. But again, I think, you know, we're just finding that lawyers aren't the complete solution. And this early part of it, getting legal information, identifying a legal problem, getting basic advice, you know, all of that needs to happen sort of pre-lawyer, even if a lawyer does need to be involved at a later stage.
That was a very interesting presentation. Lot to consider there. And I just wondered, Brian, what role you think universities might have at the level of, you know, as part of pedagogy to try to grow cohorts of willing and enterprising graduates that will take on this as a kind of as a life project for themselves and their professional development, to base themselves and commit to rural areas and rural access to justice. Yeah,
I'll share a few thoughts, and again, these are my own experience and kind of limited to this geographic space in my institution. Although, you know, having spent time and I'm regularly in Galway, you know, I guess I have some sense of some of the comparisons and talking with people in other jurisdictions. You know, I think first of all, law schools are driven by metrics, right? They are concerned with employment. They are concerned with starting salary to an extent. They are concerned with prestige. They are concerned with how everything their faculty and graduates do looks in US News rankings, ultimately. And I think that this can lead to, you know, in this space and thinking about law schools in the Midwest, a lot of lip service paid to rural practice. But especially as you go to the higher ranked institutions, you know, they see that what is going to keep them afloat, give them strength, give them clout nationally, is placing attorneys at firms in Chicago, Kansas City, Minneapolis, New York, in prestigious judicial clerkships. And so, you know, there's kind of this disconnect of the market forces for the law schools make it difficult for them to fully do the things that I think would be supportive of helping students find those opportunities. The cost of law school makes it very, very difficult for attorneys who want to do anything other than go into a salaried position. And of course, in the rural space, you know, a lot of these retiring attorneys are expecting somebody to come in as a junior partner or somebody who's going to keep what they bring in. That was their experience, again, 30 years ago, 50 years ago. So that makes it very, very challenging, as with so many things, I think, you know, given the cost of higher ed in the United States in particular. I think that law schools also have not grappled with, and again, my personal opinion here, grappled with the challenges of the changing nature of the legal practice and legal business, and recognizing that, you know, these online, I'm trying to think of the name, Zoom Legal, and what are the other ones, but these online providers here in the States, you know, they are potentially going to undercut legal services, and where they're going to hit the hardest is, you know, those attorneys who do still serve the public, smaller firms, solo practitioners. And I'm not sure that law schools are equipping that cohort of students, future practitioners, with these skills to kind of think outside the box in terms of the business model, how they're going to go out and compete with these non-lawyer online services that provide forms, provide advice, provide information for a fee. And so I think law schools probably need to be more aggressive and involved in not just saying, here are the advantages of being in a rural area, let's, engage in some matching practices, but also equipping those students with the entrepreneurial skills, with the economic skills to be able to go and compete, go and, set up shop. I mean, again, it's much more daunting for a student over the last 20 years to do what lawyers did for hundreds of years. Say, I'm going to move to this small town, hang out a shingle, and, very quickly be a community leader and be economically sound. Given the debt, it's really tough for a graduating law student to do that. And I don't know that, we fully grasped that or thought about ways to facilitate that. So I guess that's kind of my thoughts, that, law schools need to understand probably a little more what the factors are, and then, be willing or admit that they're unable to really make meaningful investments to allow students to do that. And at the same time, recognize that it's not going to be just attorneys in this legal services space going forward. Again, here in the United States, I know in the UK, there's an increasing openness to, and I assume, other countries as well. I guess US, Canada, UK are the places that I know of this, non-lawyer practitioners representing clients, in court, assisting with family law matters, assisting with housing matters. And I think that that is going to be a continuing trend across this country, and I suspect worldwide.
Very interesting set of issues there. I'm sure the same must apply to, or similar issues must apply to medics, to doctors and, rural general practice. Maybe less so vets, but certainly for I would imagine for rural general practice. But people have to leave college with such crippling debt. It's not as big a problem at this side of the world. Maybe you could import a few Irish lawyers, to go and work in rural areas. Because, it's general. Education is higher education is not free by any means, but it's we don't have that same kind of.
Well, I'll say, in a bit tongue in cheek, but you go to rural Iowa, I assume, Jessica, rural Nebraska, a lot of the doctors are foreign-born doctors. Increasingly, a lot of the clergy people are foreign-born. Yeah. Part of this is the education system is prohibitively expensive for people to return to rural areas.
It's a different business model.
Yeah.
Danielle?
Yeah, I'm going to go ahead and provide in the chat. Brian, I don't know if this will be beneficial to you or not, but just in case you weren't aware of it. So I follow a couple, Raina and I are both really really involved in restorative justice and community-based organizations and different strategies and different things like that. And so, it was interesting that you were talking about organizations that might not be lawyers, but are providing legal services. And the organization that I provided, I do know I always see them put forward calls of if someone has, legal degrees, but they also accept people to intern and volunteer who do not have any sort of legal education. And they actually train you in different things like that. So that might be something I see the future being that especially in rural communities where we may not have access to these things, these are alternatives that we could use, right, to go ahead and actually have access to justice. I also provided this website. I know it's specifically in the US. I don't know if on there you can search for non-US community-based strategies, But the website's kind of interesting because you can search not only by region, but also by the type of need that you might have. So you can do like mutual aid efforts, 911 response, or like non-911 responses, and then even like support. So whether that be like food justice or medical or legal or different things like that. So that might be something that, you know, in your future research, you can go ahead and see, like, in these rural areas, are there already organizations that are set up that are providing that access to justice in a way that you're not necessarily dealing with the criminal legal system or those systems that are adjacent to it, right?
Yeah, and I think, you know, again, with our commission, we recognize that in other areas that's already happening, you know, in a really robust way. In other, you know, needs and other social services. You know, medical clinics are partnering already with food banks, with mental health providers, and the legal profession has kind of not immersed itself in those spaces. And again, I think one of the big things is that early identification of legal need, legal issues, helping people understand that, you know, maybe their food insecurity issue, maybe their housing issue, maybe their medical issue has legal implications, and trying to connect them with information and services earlier on. So I think that's been, you know, a big lesson for us, but this is, I just took a look and this will be great to take a look at. And, you know, I think, I mean, lawyers, we're trained largely to look at problems as they've occurred in the past. You know, we're trained to say no to things, to look at the flaws and find ways, you know, not to get to yes, but the reasons why we need to say no. And I think that that means that often we have, you know, sort of this limited capacity for the creative and, you know, perhaps more cutting edge opportunities to address problems. And I think that's, you know, to our detriment, to be honest.
Yeah, it's really interesting you say that, because last night, and I think Jessica's going to be sharing the link so everyone can like listen to last night's presentation. But last night it was echoed by the presenter that whenever the students, the undergrad students, were partnering with this center, the center actually enjoyed more so the students that were not from the legal disciplines, because they were thinking of more creative like solutions and different things like that, versus like the law students kind of were like in like a very narrow-minded mindset of like how to go ahead and be solution based and respond to the crises that they were dealing with.
Well, we do need to begin to move on. So perhaps one more comment or question for Brian. I see no hands being raised. Brian, do you have a final comment?
No, I mean, I appreciate the opportunity to share this with you. I appreciate the opportunity to kind of reorganize my thoughts in the hope that we can get this off the shelf and moving forward again. And happy to follow up, happy to, you know, continue to engage on this. And I think I said this to Jessica, you know, we're kind of operating wholly, and this is just the US system and our commission, wholly in the civil space, but there are plenty of implications and a lot of relevance on the criminal side too. And I think that might be another thought. You know, here in the US, we have the Criminal Right Council. We don't have a counterpart on the civil side. And that's why I think sometimes we see this division. But when it comes down to it, a lot of the problems really do cross over those lines. And a lot of those lines are blurred in ways that, you know, again, the lawyer's mind didn't think of 20 or 30 years ago, but civil and criminal matters and non-legal matters are very much interlinked.
Will you be attending the American Society of Criminology?
Probably not.
Oh, I was going to buy you a drink and listen to you some more. Okay. I think that access to justice is so multidimensional, and in my opinion, will be the primary area that rural criminology can advance for the next 30 years, well beyond when I'm around. And so you illustrated from one point of view, and your comment at the end indicated that despite all you said, we did not even get to prosecutorial considerations of rural and access to justice. So there's much to do, and I think there should be plenty of roundtables on this at ESC, ASC, ACJS, and Academy of Criminal Justice Sciences and other places. And I know the Deason Center down in Texas is also has an interest in this. Thank you very much, Brian, for everything.